All right, good morning, everybody. We're on the record for Magistrate Court this morning. I'm looking at the main jail. Do we have a Michael Boatwright there? All right, Mr. Boatwright, can you hear me okay? All right, I can't hear him.
Speakers might be off.
Mic check over there at Maine.
Oh, can you hear me now? Can you hear me now?
All right, that's
Hello?
better. I got you.
You hear? All right, good morning, Judge.
All right, good morning. Good morning, Mr. Boatwright. You're currently being charged with 1 count of first-degree premeditated murder. The court does find probable cause. Any argument?
Your Honor, Eric Linder, on behalf of the state, I'm going to be seeking a finding of proof evident or presumption grade on this capital offense based on the arrest warrant affidavit prepared by Detective Curcio of the Broward Sheriff's Office and seeking a no bond.
Any additional argument?
Brian Reedy from the Public Defender's Office on behalf of Mr. Boatwright. I have reviewed Detective Curcio's affidavit. In light of the fact that Mr. Boatwright is currently being held no bond on several violation of probation warrants, we will reserve any argument regarding proof evident presumption great until he can appear in front of his division judge.
All right,
I would
thank
at this time invoke Mr. Boatwright's Fifth Amendment right to remain silent. I would ask that the state and any agencies of the state not contact Mr. Boatwright, attempt to interview him, or speak with him or in any way. Mr. Boatwright, I am advising you, sir, that you are not to speak to anyone about this case except for your attorney. All of your telephone calls from the jail are being monitored and recorded. If you discuss anything about the case on the phone to anyone, it will be used against you at trial later. If you discuss anything with any fellow inmates in the jail, you can expect them to be on the witness stand testifying against you at some point in the future. Do you understand?
Yes, sir.
Okay.
All right, sir, at this time, the court has reviewed the warrant and attached affidavit. It says find proof evident, presumption great, will hold you no bond. All right? You'll see your division judge.
What is it?
18008456
Thank you. All right, Dedrick Williams, is that the case you're here on, sir? Yes, Judge. Thank you, Madam Interpreter.
You're welcome, Your
Or
Honor.
do we have any other Spanish interpreter cases? Why don't you find out? And we'll go through the list right after this case with the private attorney. Thank you. Okay, is your name Dedrick Williams, sir?
Judge, I just inquired and nobody else requires a Spanish interpreter.
Thank you. All right.
Good morning, Judge Marty Padilla on behalf of Mr. Williams.
Spell your last name.
Padilla, P as in Peter, A, D as in dog, I-L-L-A.
Okay. Okay, and you're appearing on behalf of?
Mr. Dedrick Williams.
No, I mean, are you appearing, are you the attorney of record or are you
I
covering?
am the attorney of record.
Okay, I'm sorry, I
That's okay.
misunderstood.
That's okay.
Okay. All right, sir, you have an ad charge. This is for a robbery with a firearm. It's for a grand jury indictment. I do not have a copy of the grand jury indictment, or it's right over here. Okay, this is for first-degree murder with the firearm. And armed robbery with the firearm. So this is for count 4, the armed robbery with the firearm, which says count 2. Is that correct, State?
Yes, Your Honor. It's the 4th charge he's being held on. It's the 2nd count on this specific case.
Okay. All right, so what say you, State?
Your Honor, he appeared before the court previously on a first appearance for the murder charge. You found proof evident or presumption great, ordered him to be held no bond. Since then, as you mentioned, he has been indicted by the grand jury on the murder charge, and they added a charge of robbery firearm. The state filed that charge. He was ordered to be held no bond by Judge Singal, who presided over the grand jury. We're asking the court to make a similar finding of proof evident or presumption great for first appearance purposes only, based on Judge Singal's order, and hold him no bond on this count as well.
Okay, well, who previously found proof evident presumption great on this?
No one.
So I need a probable cause affidavit to find that the proof of guilt to be evident or the presumption great. So if I could get a copy of that, I'd appreciate it. We'll recall your case, okay?
Thank you, Judge. I can't, it's been sealed. I can't at this moment, at least. Judge, I believe Judge Fine, but I'd have to check. I know a circuit court judge signed the seal order. You want us to discuss this briefly and figure something out?
Sure.
Okay. I'll do
Okay,
that.
we'll put it on recall. Have a
Okay,
seat,
thank
sir. Okay, we're gonna take a break.
Your
Johnson,
present,
please.
Judge.
Okay, let's call him up.
I think his attorney is right there. He's right there. There he is.
Okay. Hello, sir. All right, we have Mr. Dedrick Williams here. Sir, we're back on your case. Let's start from the beginning, okay? Counsel, announce your appearance for the record.
Mauricio Padilla on behalf of Mr. Williams. Eric Linder on behalf of the state.
All right, and counsel, you filed a notice of appearance on behalf of Mr. Dedrick Williams?
I have, Judge.
Okay, and when did you file that approximately?
Like 3 days after his original arrest.
Okay, I just wanted to make sure it was in the court file. All right, so this is the situation we have, sir. You have a ad charge for a grand jury indictment for robbery with a firearm. I am looking at count 2 of a grand jury indictment that says you're charged with armed robbery with a firearm. We're not here for count 1, which is the first degree murder with the firearm. You've already been magistrated on that, I believe. So, State, what are you requesting on count 2?
Your Honor, the state is seeking a no bond hold on count 2 pursuant to Judge Singal's order as he presided to hold him no bond as he presided over the grand jury.
Okay, so this is what I'm gonna do. Do you have any indictment for me, Counsel, Mr. Linder?
I provided the court with the indictment.
Okay, what about the one that's written where the court can make a finding of proof evident presumption great? I could give you additional time today. We can reset this for 3, 4 o'clock.
I'm sorry, I'm just a little confused. Your Honor asked if the state has the indictment.
Yes, I'm talking about the facts that you want me to rely upon that, to find proof evident presumption great.
Your Honor,
You said before that it was a sealed indictment earlier today.
I didn't say the indictment was sealed. I said the warrant was sealed, Your Honor.
Okay, the warrant then, sir.
Your Honor, there's an order from, I believe it's Judge Colra, that the warrant is sealed. I believe I'd be violating his order if I provided the court with that warrant.
All right, well, I spoke to Judge Siegel, and he advised that we are entitled to look at the warrant in this case. So this is what I can do. I can reset this till 3 o'clock today or 4 o'clock if you want to try to get a copy of it or call your office.
Sure.
Okay? So what time? Because counselor's here, and I don't know what else you have.
I don't know, I'm sorry, Judge. I just don't know if him contacting anybody is gonna result in their producing an arrest report because they've known about this situation from the morning. So I don't think that they'll be able to give it to you. And-
All right, do you want to agree then to, because if I find proof evident presumption great, in any event, he's going to be held no bond, and he still has a right to an Arthur hearing, and you'd file a motion to set bond anyway.
That's fine, we can revisit. He's being held no bond on multiple other counts,
Okay,
so.
all right, so that's what the court will do. I'll make sure I write it on here without prejudice. And that'll be it. So, sir, you're going to be held no bond. Court is going to find proof evident presumption great per the state and defense, and this is without prejudice for you, obviously, to file a motion to set bond with your assigned division judge, which
Of course, Judge.
I understand he has the other charge, so
Okay,
you'd have to set it with that as well. Okay?
all right.
All right, thank you, sir.
Mr.
Any
Williams,
special
I'll
conditions,
see you
State?
later, Mr. Williams.
Hold on one moment. State, any special conditions? Okay, thank you very
Thank you,
much.
Judge. Thank you.
Have a good day. Counselor, do you have a card?
Yes.
Thank you. Absolutely. Thank you. Just want to put it here. You too.
Judge, he's here at Maine. Come on up, sir.
Who you working for? Hey, this is how it works, right? Man, you don't have you don't get out.
Okay, Mr. Allen, counsel, announce your appearance for the records, please.
Eric Linder on behalf of the state.
Austin Sanders, Public Defender's Office.
And,
Hector Romero with the Public Defender's Office, Judge.
all right, thank you. All right, Mr. Allen, you are here today. There is a capias not in custody for a grand jury indictment. I'm asking you to please hold it down at the main jail. You have count 1, murder in the first degree. Count 2 is robbery with a deadly weapon. And the first degree murder charge is with the firearm, and count 2 is armed robbery with the firearm. Court does find probable cause. There's a grand jury indictment. State, what say you?
Your Honor, I provided the court and defense counsel with a sworn affidavit from Detective John Curcio of the Broward Sheriff's Office. And based on the allegations in that sworn affidavit, I'm requesting that the court make a finding of proof evident or presumption great on the 2 counts before the court for first appearance purposes only and hold Mr. Allen no bond.
Okay, and before I let you go, one other thing, sir, you do have a violation of probation. You are going to be held no bond on that, and that is in case number 151452, CF10A. Okay? So we're just announcing, obviously on the violation of probation, it's no bond. So right now, we're going to address counts 1 and 2, proof evident presumption great. Go ahead, Mr. Saunders.
Yes, Judge. So in regards to the proof evident presumption grade, the state's relying on a search warrant, which is not even prepared for this proceeding, first and foremost. The second thing is that although it's detailed and it's long, and like the state said in the previous case, the length is not indicator of whether the proof evident is presumption grade. What is indicative of that is the quantum of evidence that is relied on inside of that. In this one, for this specific, Mr. Allen is mentioned only a few times in this voluminous 15-page report. And although there's many implications for the people who are believed to be co-defendants, very little is implicating to show that he had involvement in this. Without going, because I understand that it may be sealed, there's cursory associations with these people. And it says that he fits the scale and the build as his body weight, and that he associates with these people. But aside from that, I see nothing in here implicating him, specifically tying him to this. And so although there may be enough for probable cause, proof evident presumption grade I don't think relies here for this specific case for Mr. Allen. The other 3 is questionable, and reasonable minds can differ. I cited before, and I'm going to cite again, Preston versus Gee, because the state relies on Isaza. Preston is out of the 2nd District, but it's just as binding as any other case because it doesn't conflict. And in fact, Isaza cites to it as saying that the 2 cases are in conformity and aligned. In Preston versus Gee, 133rd Southern 3rd, 1218, I go down to the page right before it turns from 1226 to 1227. And I quote, the CRA, which is the criminal arrest affidavit, or the probable cause affidavit in Preston's case, fell well shy of the Russell standard in terms of both the quantum of its proof and the competence of its proof. Either one of those that lack the quantum of proof or the competence of the proof can foreclose proof evident presumption great. So I'm not arguing that a probable cause affidavit is not enough. What I'm arguing is what's alleged in this probable cause affidavit is not enough. The amount is not there. As well as I had said before, it goes on in 1227 to say that in that specific instance, the affiance, actual sworn testimony from affiance under oath with personal knowledge and evidence was submitted in that case. That mirrors Isaza. In Isaza, there was the corroborating evidence of a post-Miranda confession. We don't have that here. There was also physical corroborating evidence of the Jahseh case. We don't have that here. So because we don't have any affiant testimony sworn under penalty of perjury, because we don't have corroborating evidence, this case is a lot like Preston versus Gee. Although a probable cause affidavit can be enough to serve, it's really only if personal knowledge is existing to the people that are swearing, and we have that under penalty of perjury. Here we just have a packet that was submitted for another purpose and cursorily discusses Mr. Allen, and he should not be held by proof evident presumption great beyond the exclusion of reasonable doubt. The Russell standard says that it has to be beyond that, and we don't have it.
Your Honor, first, I'll respond with regards to what has been provided, the form that's been provided in. Your Honor, the court in Jahseh is very clear. It says, the court in Jahseh states that the state can carry its burden that proof of guilt is evident, the presumption is great, by presenting the evidence relied upon by the state in charging the crime. Well, clearly, the allegations and evidence contained in this affidavit is the evidence that the state relied upon in presenting the charges to the grand jury, in which the grand jury returned a true bill of murder in the first degree and robbery with a firearm or deadly weapon. Counsel brings up the evidence that was used in Jahseh that the court fourth found did satisfy proof evident, but nowhere in Jahseh does the fourth say this is the type of evidence that there must be in order to find proof evident or presumption great. There are all different types of evidence. That's why it's the weight, and there are different types of evidence that can satisfy proof evident or presumption great. I submit the evidence contained in this affidavit do satisfy proof evident or presumption great. And lastly, Mr. Sanders keeps referring to Preston v. G. And I submit again, reading Jahseh, the only thing that Jahseh refers to G about is that the court has to find proof evident or presumption great. That is it. So really, it should not be considered by this court for any other reason than the court must make, in order to hold no bond, the court must make that finding, which the state concedes.
I just have one, or actually two things to respond. The first is that Preston is binding because it's a different circumstance, and I'm saying that this case is more like Preston than it is in, Preston versus Gee than it is in Jahseh. So that's the distinguishing thing. Preston is binding on this in all courts in Florida until there's a conflict case, and there's not. The second thing is the state keeps saying that they presented evidence, the same evidence that they presented to get a grand jury true bill. That's not the case. They haven't presented what they presented to the grand jury true bill. What they presented to you is a summation by a police officer of what they presented, but none of that has been presented to you here, and so there can be no finding of proof evident presumption great by this court until that evidence is before you, and it hasn't been submitted.
Mr. Sanders just said before that he doesn't have an objection that a probable cause affidavit can satisfy. Now he's saying because we didn't present the exact evidence that was presented at the grand jury, you can't find it. He's got to choose one or the other. But actually he doesn't, because Jahseh does it for you, Judge.
All right, let's talk about the amount of evidence in here against Mr. Allen. Do you want to respond to Mr. Sanders'
Your Honor, I'm going to
comments?
rely upon the affidavit. We get into details. The allegations speak for themselves, Your Honor.
Okay.
Details are not really there as far as Mr. Allen. They are for everybody else. Just cursory triangulation, really.
Your Honor, there is direct evidence placing him at the scene. Your Honor, there's evidence placing him with the other co-defendants. There's video, physical evidence that's referred to, Your Honor, regarding Mr. Allen, without going into specifics.
I don't see physical evidence. I may have missed that, but I don't see physical evidence. And as far as citation, it recites, without discussing something that may be sealed, cites to somebody else's records and GPS. It doesn't say that it was his. It doesn't say it was Mr. Allen's. It talks about another person that was triangulated or located in the vicinity.
I'm talking about video at the scene.
Okay. All right. Mr. Allen, you are charged with the offense of first-degree murder with the firearm and armed robbery with the firearm. I previously found probable cause filed in your case. Actually, there's a grand jury indictment, and I find that the proof of guilt to be evident or the presumption great. Therefore, sir, you're going to be held without bond until further order of the court on the first two charges, and in fact, on count 3, the violation of probation. This order is without prejudice, sir, for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. Thank you very much. Good luck to you.
Your Honor.
Wait, hold on one second. Judge, at this time, speaking with Mr. Allen, I did advise him that at this time we are invoking his right to remain silent and not be questioned by law enforcement without counsel present, Judge.
I just want to reiterate, Mr. Allen, if police officers or anybody comes to talk to you other than your attorney, even for a different case, you don't have to talk to them. You can invoke your right on every single case, even if it's not this specific one. Understood?
Sure.
All right, so I need to know, is there any issue with this?
Your Honor, I am going to make a
Why don't you come forward and go through it and tell me if there's anything with this? So both of you can go through it. When you walk back there, you can give that to Jackie. Adele.
When you say anything with this, is that?
I want to know if there's anything in there that you want.
I'm going to be asking that the court order the clerk's office, one, to redact the entire contents of, nothing in this. I'm fine.
Well, that's what I'm asking you to go through it.
Oh, okay. No, I'm fine. As far as, I'm not
I just
advising
go through it,
anything. Yeah,
page
no,
page by page, and
no,
make
I already
sure.
went through, I think you have the same thing I have, but yeah, all right, we'll go through it. Just
Want to make sure nothing's in there.
the obscene.
How you doing, Ivy?
Well, thank you, good.
Okay, so give me that.
And the only
The
other,
bottom one goes to Jackie.
yes, the only other thing, Your Honor, and
Okay, so this search warrant and the general application.
and Your Honor, with Mr. Sanders here, just to clarify, obviously your order also applies to.
Well, we're on the record, you
No,
know.
I'm fine with
Okay.
the record. It applies with both parties that we're not to, I mean, obviously, we thought it was fine, you know, but to release to the public any.
Sure.
Details, okay.
Understood.
Any objection? Okay. All right, so, just for the record, this package right here is search warrant, the general affidavit and application for a search warrant are to be redacted and sealed, okay? Or just sealed, correct?
I was
There's
gonna
a
ask for
motion, they can
redacted
do it
because I think for seal requires a
redacted.
formal order.
Okay.
so.
Yes.
Thank you, Judge.
If anybody wants to unredact it, they can go to the division judge. I don't know who that is, but. Okay.
At this point, it is Judge Lynch. I don't know if that's how it's ultimately, it's whoever's gonna have it.
Okay, Treyvon, Demarcus, Okay, not a problem, Newsome. as long as the state and the, 1,000, sorry. Thank you. Okay, good morning, Mr. Reyes, how are you?
I'm fine, Judge. How are you?
I'm fine, thanks for asking, nice to see you. Okay,
See you.
so we have Treyvon Demarcus Newsome. Good morning, sir. You are charged with 1 count of murder in the first degree. There's no bond hold. And you also have robbery with a firearm, which is a no bond hold. Okay, state?
Your Honor, I provided both the court and Mr. Raris with a copy of a sworn affidavit from Detective John Curcio of the Broward County Sheriff's Office. I've also shown Mr. Raris a copy of the indictment against Mr. Newsome. Your Honor, based on the contents of the affidavit, I'm going to be requesting this court make a finding for first appearance purposes only of proof evident or presumption great on both counts, and that he be held no bond at this time.
Okay.
Judge, we defer any bond argument at this point in time.
Okay, so Mr. Newsome, I've reviewed the paperwork, the affidavits, and the warrants filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, sir, on both counts 1 and 2, the court is going to hold you no bond until further order of the court. This order, sir, is without prejudice for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. Good luck to you, sir. Thank you.
Thank you, Your Honor. Have a great
Nice
day.
seeing you. Maybe you could